I was standing in my driveway, staring at the certified letter in my hands, when I realized my entire life was about to become a legal nightmare. The words "Notice of Lien" were stamped across the top in bold red letters, and below that, a demand for $18,000 in unpaid homeowners association dues, plus penalties and legal fees. The problem: I had never been part of any HOA, and my property in rural Montana had been in my family for 3 generations. My name is Warren Vickers, and I inherited my grandfather's 5-acre property just outside Billings, Montana, 2 years ago. The land had been in the Vickers family since 1947, long before any subdivision or planned community existed in the area. My grandfather built the original cabin himself, and over the decades, my father expanded it into a modest but comfortable home. When I moved here from Seattle after my divorce, I thought I was escaping the complications of city life. I was wrong. The letter was from something called the Meadowbrook Hills Homeowners Association, represented by a woman named Patricia Henderson, who signed as the HOA president. I had never heard of Meadowbrook Hills, and I certainly never signed any documents agreeing to be part of their association. I went inside and pulled out all my property documents, the deed, the title, the survey maps, everything. Nowhere did it mention an HOA or any covenant restrictions. I called the number on the letter the next morning. A woman answered on the 3rd ring with a syrupy sweet voice that immediately set my teeth on edge. "Meadowbrook Hills HOA, this is Patricia speaking. How may I help you today?" "Yeah, hi. My name is Warren Vickers. I received a letter from your organization claiming I owe $18,000 in HOA dues. There must be some mistake because I am not part of any HOA." The sweetness in her voice evaporated instantly. "Mr. Vickers, there is no mistake. Your property falls within the boundaries of our community, and you have been delinquent on your dues since we incorporated 3 years ago. This is a very serious matter. Lady, I do not know who you think you are, but my property has been in my family since 1947. There was no HOA when my grandfather bought this land. There was no HOA when my father inherited it, and there sure as hell was no HOA when I inherited it 2 years ago. Mr. Vickers, I suggest you watch your language. The fact remains that your property is now within our jurisdiction, and you owe us money. If you do not pay within 30 days, we will proceed with foreclosure proceedings to recover what you owe, plus all associated legal costs." I felt my blood pressure rising. You cannot just declare someone's property part of your HOA without their consent. That is not how property law works. Actually, Mr. Vickers, when the majority of property owners in a geographic area vote to establish an HOA, all properties within that area become subject to the association's rules and fees. We followed all legal requirements. I suggest you contact an attorney if you have questions, but I can assure you that we are well within our rights. Good day." She hung up before I could respond. I sat there for a moment, stunned by the audacity of what I had just heard. Then I did exactly what she suggested. I called an attorney. The law office of Mitchell and Associates was located in downtown Billings, and I managed to get an appointment for later that afternoon. David Mitchell was a property law specialist in his mid-50s, with gray hair and the calm demeanor of someone who had seen every kind of legal absurdity imaginable. "Let me make sure I understand this correctly," he said after I explained the situation. "You inherited property that has been in your family since 1947, and now an HOA that formed 3 years ago is claiming you owe them money for all that time." That is exactly what they are claiming. They are threatening to foreclose on my property if I do not pay. David leaned back in his chair and steepled his fingers. Warren, I have to tell you, this is not the first time I have heard of something like this happening. There have been cases around the country where HOAs have tried to expand their boundaries to include existing properties without proper consent. The good news is that they almost never win these cases. The bad news is that fighting them can be expensive and time-consuming. What are my options? First, we need to examine the exact legal basis for their claim. Did they send you any documentation when they formed the HOA 3 years ago? Not that I remember. I mean, I get junk mail all the time, but I never received anything official asking me to join an HOA or vote on anything. That is important. In Montana, for an HOA to legally bind a property owner, there needs to be either a covenant that runs with the land, meaning it is recorded in the property deed, or the owner needs to have explicitly agreed to join. Let me pull up the property records and see what we are dealing with. David spent the next 20 minutes on his computer, pulling up various county records and documents. His expression grew more puzzled as he read. This is interesting. According to the county records, your property is not listed as part of any HOA covenant. Your deed makes no mention of Meadowbrook Hills or any restrictive covenants. The Meadowbrook Hills subdivision was platted in 2021, but your property predates that by decades. There is a clear boundary line between your property and the subdivision. So I am not part of their HOA. Based on what I am seeing, no, you are not. But somehow they have filed a lien against your property with the county. That should not have been possible without proper documentation, but it is there nonetheless. We are going to need to challenge this lien and potentially take them to court to clear your title. How much is this going to cost me? David gave me a sympathetic look. I will be honest with you, Warren. If we can resolve this quickly through negotiation, maybe a few $1,000s. If it goes to trial, we could be looking at $10,000 to $20,000 in legal fees. I know that is not what you want to hear. I felt sick. Even if I won, I would be out thousands of dollars defending property that was rightfully mine to begin with. What if I just ignore them? Can they actually take my property? Unfortunately, yes. If the lien stands and you do not pay or challenge it, they can eventually foreclose. Montana law does allow HOAs to foreclose for unpaid dues, even if the amount owed is relatively small compared to the property value. I have seen people lose homes worth hundreds of thousands of dollars over a few thousand in HOA fees. It is one of the more unjust aspects of HOA law. So I have to fight this. I strongly recommend it, and I think we have a very good chance of winning. The question is whether we can get them to back down without a full trial. David agreed to send a formal response to the HOA, laying out the legal basis for my position and demanding they withdraw the lien. He said it would take a few weeks to hear back. In the meantime, I tried to go about my normal life, but the stress was eating at me. I worked from home as a freelance software developer, which had been perfect when I first moved to Montana. I could live in the middle of nowhere and still make a decent living. But now, I found myself unable to concentrate, constantly checking my email and mailbox for any response from the HOA or their lawyers. 3 weeks later, I got my answer. Instead of withdrawing the lien, the Meadowbrook Hills HOA doubled down. Their attorney sent a response claiming that when the subdivision was platted in 2021, they had published legal notices in the Billings Gazette, announcing the formation of the HOA and inviting all property owners in the area to participate in the initial vote. They claimed that my failure to respond or object constituted tacit agreement to be included. David called me as soon as he received the letter. Warren, this is complete nonsense. You cannot bind someone to a contract just because they did not respond to a newspaper ad. That is not how property law works. We are going to need to take this to court. How long will that take? Could be anywhere from 6 months to a year, depending on the court schedule and how much the HOA wants to drag this out. I will file a motion to have the lien removed immediately, but they will fight it. In the meantime, I need you to do something for me. I need you to document everything you can about your property's history. Old photos, documents, anything that shows your family's continuous ownership and that the property was never part of any subdivision. I spent the next week going through boxes of old family documents in my attic. I found my grandfather's original deed from 1947, photos of him building the cabin, tax records going back decades, and even some old survey maps that clearly showed the property boundaries. I also found something interesting, a letter from 1985 when a developer had approached my father about buying the property to include in a planned subdivision. My father had refused, and the letter included language specifically acknowledging that the property would remain independent and not subject to any future HOA restrictions. David was thrilled when I showed him the letter. This is exactly what we need. This shows a clear intent to keep the property independent, and it establishes a pattern of your family refusing to be part of any subdivision. This is great evidence. The hearing for the motion to remove the lien was scheduled for early March, about 2 months after I first received the notice. I showed up at the Yellowstone County Courthouse wearing my only suit, feeling nervous and out of place. David met me outside the courtroom. "Just stay calm and let me do the talking," he advised. "The judge will hear arguments from both sides and then he will make a decision. With the evidence we have, I feel good about our chances." Inside the courtroom, I got my first look at Patricia Henderson in person. She was exactly what I had imagined based on our phone conversation. A woman in her late 40s with carefully styled blonde hair, expensive jewelry, and an expression that suggested she smelled something unpleasant. She sat next to a lawyer in an expensive suit who kept whispering to her and reviewing documents. The judge, a stern-looking man named Harold Brennan, called the hearing to order. David presented our side first, laying out the history of the property and arguing that the HOA had no legal basis to impose a lien on property that had never been part of their association. Then, Patricia's lawyer, a man named Gregory Stone, stood up. "Your Honor, the Meadowbrook Hills HOA followed all legal requirements when incorporating in 2021. We published notice in the county's newspaper of record, as required by Montana law. We held public meetings and votes. Mr. Vickers' property falls within the geographic boundaries established for the HOA, and his failure to object at the time constitutes acceptance." Judge Brennan looked skeptical. "Counselor, are you seriously arguing that a property owner's failure to respond to a newspaper ad binds them to an HOA? Your Honor, Montana Statute Section 7023-101 allows for the creation of homeowners associations when property owners in a defined geographic area vote to establish one. The statute requires notice, but does not require individual consent from every property owner. But does not the property deed need to include restrictive covenants for an HOA to have authority? Not necessarily, Your Honor. When an HOA is properly established through the statutory process, it gains authority over all properties within its boundaries." David stood up. "Your Honor, may I respond? The statute Mr. Stone is citing applies to properties within a planned subdivision. Mr. Vickers' property predates the subdivision by more than 70 years. It was never part of the platted subdivision. It is not subject to any recorded covenants, and there is clear documentation showing the family's intent to remain independent. Furthermore, Montana case law is clear that you cannot retroactively impose HOA restrictions on property without the owner's explicit consent. The judge reviewed the documents we had submitted, including the 1985 letter. After several minutes, he looked up. "I am inclined to agree with Mr. Mitchell. However, this is a complex issue that deserves a full trial. I am going to deny the motion to immediately remove the lien, but I am also issuing an order preventing the HOA from taking any foreclosure action until this matter is fully litigated. We will schedule a trial date for this summer. Both parties should be prepared to present all evidence and expert testimony at that time." It was not the outcome I had hoped for, but David assured me it could have been worse. The fact that he is preventing them from foreclosing is huge. That gives us time to prepare our case properly, and from his questions, I think he is leaning our way. The trial was scheduled for July, which meant I had 4 more months of this hanging over my head. I tried to focus on work, but it was difficult. I also started noticing strange things happening around my property. One morning in April, I went outside to find orange spray paint marking trees along my property line. I immediately called David, who advised me to take photos and file a police report. When the sheriff's deputy came out to investigate, he told me it looked like surveyor marks. "Has anyone contacted you about surveying your property?" he asked. "No, and I did not authorize this. Those are my trees on my land." 2 days later, I received a notice from the HOA claiming that I had erected an illegal fence that encroached on community property and demanding I remove it. The problem: the fence they were talking about had been built by my grandfather in the 1950s, and it was clearly on my side of the property line according to every survey and map I had. David filed a complaint with the court about the HOA's harassment, but Patricia and her group did not stop. In May, I received a citation for having unauthorized livestock on my property. I did not have any livestock unless you counted the wild deer that sometimes wandered through. Then I got cited for improper landscaping because I had not mowed my lawn to their standards. Never mind that I lived on 5 acres of mostly natural land, not a manicured suburban yard. Each citation came with a fine, which the HOA helpfully added to my supposed debt. By June, they claimed I owed them over $25,000. "This is harassment, plain and simple," David told me. "They are trying to pressure you into settling. Do not give in. We are going to present all of this to the judge as evidence of bad faith on their part." As the trial date approached, I spent hours helping David prepare. We gathered every document we could find about the property's history. David also hired a surveyor to do an official survey, which confirmed that my property had clear, established boundaries that had never been part of the Meadowbrook Hills subdivision. We also deposed Patricia Henderson. That was an experience I would not forget. She sat in the conference room at David's office, dressed in a power suit and radiating hostility. "Mrs. Henderson, when did you first become aware of Mr. Vickers' property?" David asked. "When we were forming the HOA in 2021. His property is right in the middle of our community, and it is an eyesore. He does not maintain it to our standards. But the property predates your community by 70 years. Did you not think it might not be part of your association? The law is clear." When we formed the HOA, all properties in the area became part of it. If he did not want to join, he should have objected at the time. "Did you personally send notice to Mr. Vickers?" "We published notice in the newspaper, as required by law." "But did you send direct notice to Mr. Vickers, knowing his property was in the area?" Patricia hesitated. I do not recall. David pulled out a document. According to the county records, you have Mr. Vickers' mailing address on file because you have been sending him citations and notices for the past several months, so you knew how to contact him. Why did you not send him direct notice when you were forming the HOA? I do not have to answer that. We followed the legal requirements. Mrs. Henderson, is not it true that you and the other HOA board members specifically targeted Mr. Vickers' property because you want to force him to sell so you can expand your subdivision? That is ridiculous. Is it? Can you explain why the HOA filed a request with the County Planning Commission last year to rezone Mr. Vickers' property from agricultural to residential? Patricia's face flushed. That was just preliminary planning. Every community needs to think about future growth. Without the property owner's knowledge or consent, the deposition went on for 3 hours, and by the end, Patricia was visibly angry. As she left, she stopped by me in the hallway. "You are making a big mistake fighting this," she hissed. "You cannot win. We have lawyers, we have money, and we have the law on our side. You should just pay up and save yourself the trouble." "I will see you in court," I replied calmly, though my heart was racing. The trial began on a sweltering Tuesday in mid-July. The courtroom was packed. Apparently this case had attracted attention from other property owners in the area who were concerned about similar tactics by HOAs. Judge Brennan presided, and he made it clear from the start that he wanted to hear all the evidence before making any decisions. The HOA's lawyer, Gregory Stone, presented their case first. He argued that Montana law allowed for the creation of HOAs through a democratic process, and that proper notice had been given. He showed copies of the newspaper ads and minutes from the initial HOA meetings. He claimed that my property fell within the boundaries of the community, even though I disagreed. "Your Honor, this is not about whether Mr. Vickers wants to be part of the HOA," Stone argued. "This is about whether the HOA was properly formed according to law, and we have shown that it was. Once properly formed, the HOA has authority to levy assessments on all properties within its boundaries. Then it was our turn. David methodically went through the history of my property, starting with my grandfather's purchase in 1947. He showed photos of the original cabin, tax records, and survey maps. He presented the 1985 letter showing my father's explicit refusal to be part of a subdivision. "Your Honor, this is not just an old property," David explained. "This is a property with a clear, documented history of independence. The Vickers family has consistently maintained that this land is not and will never be part of any subdivision or HOA. The current HOA was created in 2021, and at no point did they obtain Mr. Vickers' consent to include his property." David then called me to the stand. I testified about inheriting the property, about never receiving direct notice of the HOA formation, and about the harassment I had experienced over the past several months. "Mr. Vickers, you maintain your property?" David asked. "Yes, I do. I keep the house in good repair. I mow the areas around the house, and I maintain the driveway. It is a rural property, not a suburban lawn, so it looks different than the houses in the subdivision." "Have you ever agreed to be part of the Meadowbrook Hills HOA?" "Absolutely not. I never even heard of them until I got the lien notice." On cross-examination, Stone tried to make me look like I was just trying to avoid paying my fair share. "Mr. Vickers, is not it true that you benefit from living near the Meadowbrook Hills subdivision? The roads are better maintained, the area is safer, property values have increased." "I do not use their roads. I use the county road that has been here for decades, and I do not know how their subdivision makes my property safer. My property value has nothing to do with them. It is valuable because of its location and acreage. But you enjoy the benefits of living in an improved area without contributing to the costs. Does not that seem unfair? What seems unfair is an HOA trying to force me to pay for something I never agreed to and do not want. If I wanted to live in a subdivision with an HOA, I would have bought property in one. The questioning went on for over an hour, but I stuck to my guns. When I stepped down, I felt exhausted but relieved. David then called our surveyor as an expert witness. He testified that my property had clear, established boundaries that predated the subdivision by many decades, and that there was no overlap between my property and the platted subdivision. In your expert opinion, is Mr. Vickers' property part of the Meadowbrook Hills subdivision? David asked. No, it is not. The property boundaries are clear and unambiguous. Mr. Vickers' property is a separate parcel that was never included in the subdivision plat. Finally, David called a property law expert from the University of Montana. Professor Ellen Reeves had been studying HOA law for 20 years and had written extensively on property rights. Professor Reeves, can an HOA legally claim authority over property that was never part of the subdivision it serves? Not under Montana law. For an HOA to have authority over a property, there must be either a covenant that runs with the land, meaning it is recorded in the deed, or the property owner must have explicitly agreed to join. You cannot retroactively impose HOA restrictions on existing property without consent. What about the argument that newspaper notice is sufficient? Newspaper notice might be sufficient for some purposes, like announcing public meetings, but it is not sufficient to bind a property owner to an HOA. That requires direct notice and an opportunity to consent or object. Think about it this way: if newspaper notice were sufficient, an HOA could claim authority over any property in a county just by publishing an ad. That would be absurd and clearly unconstitutional. Stonecross examined her aggressively, but Professor Reeves held her ground. She cited case after case supporting our position. The trial lasted 3 days. On the final day, both lawyers made their closing arguments. Stone insisted that the HOA had followed the law and that I was simply trying to avoid my responsibilities. David argued that the whole thing was an overreach by an HOA trying to expand its power beyond its legal authority. Judge Brennan said he would take the matter under advisement and issue a written ruling within 30 days. Those 30 days were some of the longest of my life. I tried to stay busy with work, but I found myself constantly wondering what the judge would decide. Everything was riding on this: my home, my family's legacy, my peace of mind. The ruling came on a Friday afternoon in mid-August. David called me as soon as he got it. "Warren, we won." We won completely. I felt dizzy with relief. What did the judge say? Let me read you the key part. The court finds that the plaintiff, Meadowbrook Hills HOA, has failed to establish any legal basis for claiming authority over the defendant's property. The property in question predates the HOA by more than 70 years, was never part of the subdivision plat, has no recorded covenants or restrictions, and the owner never consented to join the HOA. The HOA's claim that newspaper notice is sufficient to bind a property owner to its authority is without merit and contrary to Montana law and basic principles of property rights. The court orders that the lien filed by the HOA be removed immediately and that the defendant owes no money to the HOA. Furthermore, the court finds that the HOA's actions in this case, including filing an improper lien and harassing the defendant with baseless citations, constitute bad faith and abuse of process. The court awards attorney's fees and costs to the defendant in the amount of $17,000 to be paid by the HOA within 60 days. I could not believe what I was hearing. Not only had I won, but the judge was making them pay my legal fees. Are you serious? Dead serious. The judge saw right through their tactics. This is a complete victory, Warren. Your property is free and clear, and they have to pay for putting you through this. I felt like a massive weight had been lifted off my shoulders. Thank you, David. I could not have done this without you. You are welcome. I will file the order with the county today to get that lien removed. You should be clear within a week. I thought that would be the end of it, but I was wrong. 2 weeks later, I received a call from a detective with the Billings Police Department, Mr. Vickers. This is Detective Sarah Chen. I was hoping you could come down to the station to answer some questions about the Meadowbrook Hills HOA. What kind of questions? We are investigating some irregularities in the HOA's financial records and activities. Your case came to our attention, and we would like to hear your story. I met with Detective Chen the next day. She was a sharp woman in her 30s with a no-nonsense attitude. I told her everything that had happened, from the initial lien notice to the trial and the judge's ruling. Did Patricia Henderson or anyone else from the HOA ever offer you any kind of deal to make this go away? She asked. No, they just kept demanding money and harassing me with citations. What about threatening you or your property? I thought about the mysterious survey marks and the various citations. I am not sure if it rises to the level of threats, but they definitely tried to intimidate me. Why? What is this about? Detective Chen leaned back in her chair. Between you and me, you are not the first person to complain about this HOA. We have had several reports of questionable tactics, and when we started looking into their finances, we found some serious problems. It looks like Patricia Henderson and 2 other board members have been embezzling HOA funds. They have also been filing bogus liens against properties to try to force sales so they could profit from the transactions. Are you kidding me? I wish I was. We are building a case, but it takes time. Your situation actually helps us because the judge's ruling establishes that their tactics were improper. That gives us leverage in the criminal investigation. What happens now? We continue investigating. When we have enough evidence, we will make arrests. I wanted to talk to you today because you might be called as a witness if this goes to trial. Would you be willing to testify about what they did to you? Absolutely. They put me through hell for 6 months. The investigation continued through the fall. In October, I read in the Billings Gazette that Patricia Henderson, along with 2 other HOA board members, had been arrested on charges of fraud, embezzlement, and extortion. The article detailed how they had stolen over $200,000 from HOA funds and had attempted to seize several properties through fraudulent liens. David called me when he saw the news. Did you see this? Yeah, I just read it. I cannot believe they were running such a big scam. It explains a lot, though. They were not just power-hungry, they were criminals. I am glad the judge saw through them. The criminal case moved slowly through the system, but by spring of the following year, all 3 defendants had pleaded guilty to various charges. Patricia Henderson received a 3-year prison sentence and was ordered to pay restitution. The other 2 board members got lighter sentences, but also had to pay back what they stole. The Meadowbrook Hills HOA itself went through major changes. The remaining homeowners voted to dissolve the old board and elected new leadership. One of the first things the new board did was send me a formal apology letter, acknowledging that I had been wrongly targeted and confirming that my property was not and never had been part of their association. As for me, I finally got some peace and quiet. The lien was removed from my property records. The HOA paid the attorney's fees as ordered by the judge, and I was able to go back to my normal life. I continued working from home, enjoying the rural Montana lifestyle that I had moved here for in the first place. I also became something of a local expert on fighting improper HOA claims. Several other property owners who were having similar issues contacted me for advice, and I was happy to share my story and connect them with David. In a couple of cases, just the threat of litigation based on my successful case was enough to get the HOAs to back down. Looking back on the whole experience, I learned several important lessons. First, never assume that an official-looking document is legitimate just because it comes from an organization with an official-sounding name. Second, property rights are fundamental, and they are worth fighting for. Third, there are people out there who will try to abuse positions of power for personal gain, but the legal system can work if you are willing to stand up for yourself. My property is still here, just as it has been since 1947. The old cabin my grandfather built is still standing, now incorporated into the expanded house. The trees he planted are tall and mature. The land that he cleared and cultivated is still productive, and most importantly, it is still independent and free from any HOA control. I sometimes drive past the Meadowbrook Hills subdivision and see the neat rows of houses with their manicured lawns and uniform mailboxes. It is not a bad place, and under new management, the HOA seems to be functioning properly for the people who chose to live there. But it is not for me. I prefer my 5 acres of freedom, where I can let the grass grow long, where deer wander through in the evening, where I can sit on my porch and not worry about citation notices or compliance letters. The experience did change me in some ways. I am more cautious now, more aware that even in rural Montana, you cannot completely escape bureaucracy and people who want to exercise control over others. I keep all my property documents in a fireproof safe, and I make sure my deed and title are recorded correctly with the county. I also stay informed about local government meetings and planning decisions, just in case anyone tries something similar in the future. But mostly, I am just grateful. Grateful that I had the resources to fight back, grateful that I found a good attorney, and grateful that the judge saw through the HOA's tactics and ruled in my favor. Not everyone in my situation would have been so lucky. Some people might have given up or might not have had the money for a lawyer. Some might have lost their property to a fraudulent foreclosure. That is why I still tell my story whenever someone asks. Because property rights matter, and people need to know that they do not have to just accept it when an HOA or any other organization tries to overstep its authority. There are laws protecting property owners, and those laws mean something. One afternoon in early summer, almost 2 years after that first lien notice arrived, I was working in my garden when a car pulled up my driveway. I tensed for a moment, old habits from the HOA battle dying hard, but then I saw it was just a young couple looking lost. "Can I help you?" I called out as they got out of their car. "We are so sorry to bother you," the woman said. "We are looking at properties in the area, and we saw your place from the road. It is exactly the kind of place we have been dreaming about. Would you ever consider selling?" I smiled and shook my head. "No, I am sorry. This property has been in my family for 3 generations, and I plan to keep it that way." The man nodded understandingly. "We figured, but we thought we would ask. It is beautiful out here. Are you part of the Meadowbrook Hills community?" "No," I said firmly, "and I never will be. But if you are looking for property in the area, I would suggest looking for something with clear title that is not part of any HOA, unless you specifically want that. It will save you a lot of potential headaches." They thanked me and left, and I went back to my garden. The sun was warm, the breeze was gentle, and everything was peaceful. This was exactly what I had wanted when I moved to Montana, and after everything I went through to keep it, I appreciated it even more. I thought about my grandfather sometimes, building that first cabin with his own hands, clearing the land, putting down roots. He probably never imagined that 70 years later, his grandson would have to go to court to defend what he built. But he would have approved of the fight. The Vickers family did not give up what was ours without a battle. The legal documents from my case are filed away safely now, along with all the other family papers. The judge's ruling is particularly important, not just for what it means for my property, but for what it establishes as precedent. David told me that other attorneys in Montana have cited my case in similar disputes, and in at least 3 instances, HOAs have backed down rather than face the same kind of ruling. That makes me proud. Not just that I won my case, but that my fight might have helped protect other people's property rights too. That is worth something, maybe even worth all the stress and expense and sleepless nights. As summer turned to fall, I settled into a comfortable routine. Work was going well, the property was in good shape, and I had even started dating someone I met at a local coffee shop in Billings. Life was good and getting better. One October morning, I received a letter from the new Meadowbrook Hills HOA board. For a moment, my heart sank, but then I opened it and found it was just an invitation to a community barbecue. The letter emphasized that it was open to all neighbors, whether they were part of the HOA or not, and that it was just a friendly gathering with no strings attached. I thought about it for a day, and then I decided to go. Not because I had forgiven and forgotten what the old board put me through, but because these were new people who had cleaned house and were trying to do things right. Plus, they were my neighbors, even if I was not part of their association. The barbecue was pleasant. I met several of the homeowners, and they were genuinely nice people. A few of them apologized for what the previous board had done, even though it was not their fault. One man told me that he had voted against Patricia Henderson when she was running for HOA president, but had been outvoted. We should have listened to the people who had concerns about her, he said. She always seemed more interested in control than in actually serving the community. But we learned our lesson. The new board is transparent, we publish all our financials, and we do not try to expand our authority beyond our actual boundaries. I am glad to hear it, I told him. I have nothing against HOAs in general, just against people who abuse them for personal gain. As I drove home that evening, I reflected on how far things had come. A year ago, I was in court fighting for my property. Now I was having pleasant conversations with my neighbors at a barbecue. Life had a funny way of working out sometimes. The experience also gave me a deeper appreciation for the legal system, despite its flaws. Yes, it was expensive and time-consuming to defend my rights. Yes, it was stressful and frustrating. But in the end, the system worked. The judge looked at the evidence, applied the law fairly, and made the right decision. That is all anyone can ask for. I also gained a new respect for good attorneys like David Mitchell. He could have just taken my money and gone through the motions, but instead he fought hard for my case because he believed it was right. He saw the bigger picture, that this was not just about one property owner and one HOA, but about fundamental principles of property rights and consent. As winter approached and the Montana landscape turned white with snow, I found myself more content than I had been in years. The stress of the divorce that had driven me to Montana in the first place seemed like ancient history now. The battle with the HOA, while difficult, had given me a sense of purpose and accomplishment. And the life I was building here felt solid and real in a way that my old life in Seattle never had. I spent Christmas alone that year, but it did not feel lonely. I cooked a nice dinner, built a fire in the fireplace, and looked through old family photo albums. There was my grandfather in front of the newly built cabin, young and strong and proud. There was my father as a boy, playing in the dirt with a toy truck. There were dozens of photos documenting decades of family history on this land. And now, I was part of that history, another chapter in the ongoing story of the Vickers family property. My chapter included a legal battle that became part of the public record, a small contribution to property law in Montana. Not a bad legacy, all things considered. As the new year began, I made a resolution to stay vigilant but not paranoid. The HOA situation had taught me to be careful and to protect what was mine, but I did not want to spend the rest of my life looking over my shoulder. There had to be a balance between awareness and anxiety, between protecting my rights and actually enjoying my property. I also made a resolution to be more involved in local government. I started attending county commission meetings occasionally, especially when they were discussing zoning or planning issues. I wanted to make sure that nothing like the Meadowbrook Hills situation could happen to someone else if I could help prevent it. In February, I was surprised to receive a call from a journalist at Montana Public Radio. She was doing a story on HOA overreach and had heard about my case. Would I be willing to be interviewed? I agreed, and a week later, the story aired. It was a fair and balanced piece that explained the situation clearly and used my case as an example of both the problem and the solution. The journalist interviewed me, David, Professor Reeves, and even one of the new Meadowbrook Hills board members who talked about the reforms they had implemented. After the story aired, I got several emails and calls from people thanking me for speaking out. One man said he was in a similar situation in Great Falls, and that hearing my story gave him courage to fight back. Another woman said she was researching properties to buy, and that my case had taught her to carefully check for HOA restrictions before purchasing. It felt good to know that something positive had come from my ordeal. Maybe my story would prevent someone else from going through what I went through. Maybe it would make some HOA boards think twice before overstepping their authority. Or maybe it would just make people more aware of their property rights. Any of those outcomes would be worthwhile. By March, the whole situation felt like it belonged to the past. The lien was gone. The legal bills were paid by the HOA as the judge ordered, and my property was secure. I had even refinanced my mortgage at a better rate, something I could not have done with the lien on my title. Life was moving forward, and the HOA nightmare was receding in the rearview mirror. I did keep in touch with David, though. We had developed a friendship during the case, and we occasionally met for lunch in Billings. He told me about other cases he was working on, some similar to mine and some completely different. He had become something of a specialist in fighting HOA overreach, and he was winning more cases than he lost. "You know, your case changed my practice," he told me over lunch one day. "I always did property law, but I never really focused on HOA disputes until your situation. Now I probably get 2 or 3 calls a week from people having problems with their HOAs. Some of them are legitimate disputes that need to be negotiated, but some of them are just like yours, HOAs trying to expand their power beyond what the law allows." "Glad I could help," I said with a laugh. "Though I would have preferred not to need your services in the first place." "I know, but you did the right thing fighting back. A lot of people would have just paid the money to make it go away, even though they did not owe it. That just encourages the bad actors." He was right, of course. One of the reasons HOAs sometimes get away with improper behavior is that people find it easier to pay up than to fight, even when they are in the right. It is a form of legal extortion, and it only stops when people are willing to stand up and say no. As spring arrived and the snow melted, I started planning some improvements to my property. I wanted to build a new workshop and maybe expand my garden. In the past, I might have worried about whether an HOA would approve my plans. Now I just did what I wanted, secure in the knowledge that my property was truly mine. I did check with the county to make sure I was following proper building codes and zoning regulations. I was not against all rules, just against unjust ones that were imposed without consent. Reasonable regulations that applied equally to everyone and served legitimate public purposes were fine. What was not fine was an HOA trying to force its aesthetic preferences and fees on someone who never agreed to join. In May, I hosted a small party for friends I had made in the area. We grilled steaks, drank beer, and enjoyed the warm evening. At one point, someone asked me about the HOA situation, having heard about it through the grapevine or maybe from the radio story. I gave them the short version, and when I finished, another friend raised his beer and said, "Here is to property rights and not backing down." Everyone joined in the toast, and I felt a warm sense of camaraderie. These were people who understood the value of independence and the importance of standing up for what was right. They were my kind of people, and this was my kind of place. As the evening wound down and people started heading home, I stood on my porch looking out at my land. The mountains were visible in the distance, the sky was full of stars, and everything was peaceful. This was what I had fought for, not just the legal right to own the property, but the actual enjoyment of it. The freedom to live my life without interference, to make my own decisions, to be answerable to no one but myself, and the reasonable laws of the community. It had been a long journey from that first certified letter to this peaceful evening, but it had been worth it. I had learned a lot about the law, about myself, and about what really mattered, and I had come out the other side stronger and more secure. The Meadowbrook Hills HOA tried to seize my land for unpaid dues, but in the end, the judge said I never owed them anything. More than that, he said they had no right to even try. That ruling was now part of the permanent record, a small but important precedent that would help protect other property owners in Montana for years to come. And as for Patricia Henderson and her fellow board members who had used their positions to steal and intimidate, they were behind bars where they belonged. Justice had been served, both in the civil case and in the criminal prosecutions that followed. I went inside, made myself a cup of coffee, and sat down at my computer to do some work. Outside, the night was quiet except for the occasional sound of wildlife. This was home, this was sanctuary, and this was mine. No one could take it away from me because I had stood up and fought for it when it mattered most. The story could have ended badly. I could have lost my family's property to a fraudulent foreclosure. I could have been bankrupted by legal fees. I could have given up and paid money I did not owe just to make the problem go away. But none of those things happened because I chose to fight, because I found a good attorney, and because the legal system ultimately worked the way it was supposed to. Not everyone is so lucky, and that is why I continue to tell my story. Because people need to know that they have rights, that those rights are worth defending, and that sometimes you can win even when you are facing an organization that seems more powerful than you are. You just have to be willing to stand your ground and see it through to the end. As I worked late into the night, I occasionally glanced out the window at my property, dark and peaceful under the Montana sky. Somewhere in Billings, the court records contained the complete history of my case, available to anyone who wanted to look them up. Somewhere in the county records, my deed was properly recorded with no liens or encumbrances. And somewhere in a state prison, Patricia Henderson was learning that you cannot build your life on other people's property and other people's money. The whole experience had made me a stronger person and a more informed citizen. I understood property law now in a way I never had before. I understood how HOAs could be both useful and dangerous, depending on who was running them and how much power they tried to claim. And I understood the importance of documentation, of keeping good records, of knowing exactly what you own and what restrictions apply to it. These were lessons that would serve me well for the rest of my life, and lessons I could pass on to others who might face similar situations. Knowledge is power, and the knowledge I gained through this ordeal was hard-won but valuable. As summer arrived again, marking a full year since the trial, I realized that I had fully moved on from the trauma of the HOA battle. It was part of my history now, an interesting story to tell, but not something that dominated my thoughts anymore. I was focused on the present and the future, on building the life I wanted on the land I loved. And that, ultimately, was the real victory. Not just winning in court, not just getting the lien removed, but reclaiming my peace of mind and my enjoyment of my property. Patricia Henderson and her corrupt board had tried to steal that from me, but they failed. The judge made sure of that with his clear, unequivocal ruling in my favor. I never owed them anything, and now everyone knew it.